Good morning, everyone. It's Thursday, August 18th, 2022, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Lincoln, would you please call the roll?
Commissioner Baker?
Here.
Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Chair Matich?
Here. Good morning, everyone. I'll start with one announcement you may have seen from our press release, but the Attorney General recently appointed a new member of our commission, Dr. Jose Gomez from Cal State LA. Unfortunately, Commissioner Gomez was not able to join us today, but we look forward to him joining us next month in September. So with that announcement, we'll go ahead and proceed to item 1, public comment for items not on today's agenda. Do we have any public comment? And seeing none, we'll proceed to item 2, approval of the July 2022 Commission hearing minutes. Do any commissioners have edits or comments on the meeting minutes?
Move to approve.
Second. Is there any public comment on item 2? None. Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Now proceed to our consent calendar, which consists of items 3 and 4 today. Do any commissioners wish to pull an item from the consent calendar for separate debate?
No, Chair Matich, but I do have a question regarding item 4.
Right. Go ahead.
Commissioners, I have a question I'd like to pose to Chief Brereton. I know that, your team does extensive work on, computing what the fines are for particular cases. But if you could be so kind to explain why item number 4, relating to Mr. Isaac Galvin, is $240,000, which is a fairly high amount. Thank you.
Certainly. Good morning. So we, as you mentioned, we are proposing a $240,000 penalty in this case for 53 counts. Most of the violations here involve deliberate and intentional conduct, which, in our scheme of penalties, that garners the highest. Part of this case also involves contributions and campaign funds that were used for personal use. So as you know, contributions are held in trust for the use of political, legislative, and governmental purposes. But here the evidence shows that a considerable amount was used for personal use. Many of the transactions were in cash or in other forms that prohibited us from being able to determine if there were other violations that occurred. There was an intent to conceal this activity because no campaign statements were filed after a certain amount of time, particularly during the periods where cash was used and where the personal use violations occurred. So all of that together led to a high degree of public harm here. The use of cash and other types of medium also led to the true sources of those contributions or the recipients of those expenditures being concealed as well. Galvin was in office during this entire period. So he's, representing his district in the city council while using campaign funds in ways that are not allowed under the law, and inhibits the public from knowing exactly what's going on with his campaign and with the funds that people have given him to support his campaign. Also, Galvin has not participated at all in the process. We personally served the accusation in this matter, and he has not been in contact with us, nor anyone on his behalf. And so based on the totality of the circumstances here and the evidence that we have available, we believe that $240,000 is the appropriate penalty for this case.
Thank you, Chief Brereton, for the detailed explanation. Thank you.
You're welcome.
Thank you. When we're in a default proceeding such as this, are we, as the enforcement team, take the allegations as true or as admitted or on their face? And how much investigation do we do when it's a default proceeding? I'm kind of curious if you can address that.
So it's the same amount of investigation as we would prepare for going to a hearing. The main difference is that we don't have the opposing party who is giving us their interpretation of the evidence that we're presenting. So it's the same types of evidence that we would gather and present if we were before a judge. That we just don't have the benefit of having the other side there to give us some kind of interpretation, or even saying, no, that's not what this really says. So we are going with the evidence that we have and taking it at face value because we don't have another interpretation.
Very helpful. I just want to get that out there as well, is that the team has done quite a bit of work. It's not like it goes on autopilot for something like this. So thank you.
That's correct.
Any further questions for Chief Brereton on the consent calendar? Well, it's not a question, it's an observation. I would just say item 3 on the consent calendar is something that's coming back to us from a prior meeting where we had given some direction on that stipulation. And I just want to express my gratitude to staff and to you, Chief Brereton. I think that the new stipulation presented in item 3 is much improved on the original stip, and the fine amount is consistent with our view of the violations there. So I just wanted to take a moment to acknowledge that you went back, you worked hard at this, and the product is very good.
Thank you.
So with that, I'm going to move approval of the consent calendar, items 3 and 4. Do I have a second?
Second.
Any public comment on the consent calendar? And seeing none, Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Right. Moving to our general items. Item 5. This is our pre-notice discussion of proposed amendments to Regulation 18410, requiring disclosure of all individuals authorized to access a committee's bank records. And with us this morning is Commission Counsel Caitlin Green. Joining her at the dais will be Audit Division Chief Shraddha Shah.
Okay. Good morning, Chair and Commissioners. Caitlin Green, Commission Counsel, presenting for pre-notice discussion, amendments to Regulation 18410 to require a committee to disclose on the Statement of Organization, Form 410, the names of all individuals who have authorization to obtain a committee's bank account records from the financial institution where the account is maintained. We also have Audit Division Chief Shraddha Shah here to answer any audit-specific questions that may come up, if any. So these amendments come as a request from the Commission's Audit Division to assist with completing audits more efficiently. As discussed in the attached memo, without knowing the individuals who have the authority to obtain the financial records from the committee when the treasurer is unavailable, it takes time and resources to locate this information, including utilizing the Commission's Enforcement Division to issue subpoenas. In addition, requiring this disclosure is consistent with the purpose and provisions of Chapter 4 of the Act on Campaign Disclosures, as specified in Section 81002, in that it provides additional transparency on a committee's receipts and expenditures. Staff recommends the proposed disclosure be disclosed in the Name of Financial Institution field on page 2 of the Form 10, a copy of which was provided for reference. This will limit the need to rearrange the form to accommodate the additional information by creating a separate field, and to eliminate the burden on Commission staff, as well as the Secretary of State's current online filing system. As a result, the Form 410 will need to be amended. So staff recommends delaying the effective date of these regulation amendments to January 1st, 2023, to allow time for staff to update the Form 410. I would also like to note that we did reach out to staff at the Franchise Tax Board, and they see no concerns with adding this language into the regulation, and they have expressed that it will also likely benefit their political reform audit program and will assist in resolving their audits timely. With that, I'm happy to take any questions or comments, as well as any further guidance from the Commission on these proposed regulation amendments.
Thank you, Ms. Green. I want to start with a question that was prompted by one of the comment letters we received. We received a comment letter from the California Political Attorneys Association, and one of the concerns that they identified is that if we went forward with this regulation, that the names of all of the committee's account signers would suddenly be publicly available. Now, I understand our regulation not to be directed at signers of checks, but instead to be directed at identifying individuals with access to financial records to solve the problem that you articulated at the beginning of your presentation. Can you clarify, is that a correct understanding? This isn't about signers, it's about authorized access?
That is correct. Although we do state that this regulation is about bank account signers, what we want to encompass are those individuals that have the authorization to obtain the financial records from the financial institution where that account's maintained, whether that's online or in person. And so that's, even if they're not a signer in that case, if they have the authority, then it would encompass that individual.
Okay, I appreciate that clarification. Do other commissioners have questions for Ms. Green? Commissioner Baker?
Thank you. Both a comment and a question. I think, well, I'll start with the question, actually. So not being able to access records, I feel like in the last year and a half or more that I've been on the commission, that's one of the obstacles that the enforcement team in their investigation and I imagine audits has to deal with. And I imagine it costs time. I don't know that we've done anything to say, here's the range of time, but maybe if you could start by just providing some insight on how frequently this is a problem for our team as they are trying to do expeditious investigations. I know it might not be something you can quantify, but I'm curious if you can make more observations on that. Please, either.
Good morning, Commissioners. So yeah, it does happen quite frequently. We've seen cases where it has caused significant delays in our audit, and by significant, I would say from months to about a year, especially if the individual we are trying to reach out to is unresponsive in general, or sometimes they move out of the state and we have no idea that they have moved out of the state. So trying to track down the correct person has certainly created obstacles for us. So staff has to walk around, try to find out who to reach out to, how do we obtain the documents, which nobody in general would know. They cannot access these bank records if they're not authorized signers or authorized users.
Thank you. I think that's why I'm very interested in this regulation going forward with good feedback that we may receive. Maybe we'll need to make some adjustments to it based on input we have. But anything we can do to have an expeditious resolution of the investigation our team undertakes with the limited resources it already has will be very helpful. I think the public would benefit from that. The regulated community would benefit from it. And this seems like I want to say unnatural or a removable obstacle. And so I'm grateful that this regulation is coming forward for us. With respect to the feedback we've received so far, I appreciate the distinction between signatory and access. I don't know if we don't need to negotiate against ourselves. If you look at, if we receive more feedback going forward, since this is pre-notice, if having at least 2 or 3 or saying a number of people who have access to the account might be helpful, so that we at least have some additional people to go forward with. I just want to put that out there as one potential consideration for your team to look at. And if it comes back to us, no, we don't recommend that, it'd be helpful to talk about it, but I think that's worthy of conversation going forward. Thanks.
Thank you.
Commissioners have questions or comments? Commissioner Wood?
I do just have something small, but I noticed in the comment letter a mention, and I don't have it pulled up in front of me, I'm sorry, but a mention about maybe adding to the regulation that it will be redacted. And so I just wanted to say, that's fine with me. I don't have a problem with that part, if the other commissioners agree, but I don't feel super strongly about it.
I appreciate that, Commissioner Wood. My understanding is that the other agencies, the Secretary of State's office, local filing officers do redact per their policy, and so that is, it's weird. We craft this rule, but those documents are actually filed with somebody else, and so I don't disagree. Maybe we can put that in the regulation with an understanding, of course, that the other agencies have the ability to redact or not redact, even if we encourage them to do so.
So this raises something that, just as an administrative law professor, I'm kind of curious about. Would we ever bring this forward as a joint regulation with those other agencies? I mean, and that's not just an academic question, right? Like if we would be overstepping our bounds by talking about redacting here, or by trying to get them to redact, if we were to bring it forward jointly with them, maybe that would be less of a concern. But I can barely see your face because I have our Caitlin really big right now, but you look unconvinced, Mr. Chair.
I'm gonna punt this over to Mr. Bainbridge because I'm just gonna, Mr. Bainbridge, why don't you address that?
I know I'm in trouble when she brings up administrative law professor questions. I think the answer to that is we would work with them, and we commonly work with SOS, obviously, because we work so closely on campaign filing in general. And so I don't know that we would have joint regs, because we each have our own regs and different processes for approving them and different jurisdiction. But if we were to add that, we would certainly be in contact with them and work with them on what we think should be redacted. And usually in prior similar instances, we're able to come to a pretty good understanding and end up in the same place on these sort of things.
Thank you. Good to see you, Dave.
You too.
So that actually, I have a question now. If we, for the regulations that we can control ourselves, could we add something to the regulation to address the concern about redaction that says that the obligation to identify these additional individuals with access only applies when the filing officer in receipt of those has a redaction policy? We could do that ourselves without waiting for the other agency to take action, right?
Yeah, that's correct. We could include in this regulation language that states that the names of these individuals should be redacted, maybe similar to how bank account numbers are redacted.
For my part, consistent with Commissioner Wood's comment and what was in the CPA letter, I'd encourage staff to give some thought to how we might be able to craft that into the regulation to help improve it.
Yeah, I was going to say that's an excellent idea. I mean, the main reasons that you need the names of everyone who's tied to the account is for your purposes, but not necessarily to display that to the public. So, you know, the chair and Commissioner Baker's recommendation makes total sense. So thank you.
Any other commissioner comments for staff? Is there any public comment on this item?
Yes, good morning, Commissioners and Chair. This is Emily Andrews with the California Political Attorneys Association. Thank you for consideration of the letter that we submitted. I do have a couple of comments in response to some of the discussion regarding the points raised in our letter today, and also just want to kind of, I think, elaborate a little bit on the discussion that we've had action. So thank you for your consideration of our comments. You know, as noted in our letter, the concern from CPAA is really a financial fraud risk concern. You know, I think all of us who are responsible for campaign bank accounts have in recent years in particular seen a real uptick in the amount of potential fraud and folks who are various actors trying access to campaign bank accounts. So, we're very mindful of fraud risk and making sure that we're being as protective of the dollars in these accounts. One thing I did want to just comment on was the discussion regarding, how this regulation would apply to disclosure of signers on bank accounts versus individuals who have access to the bank accounts. I see that there is a distinction, but I actually think the distinction is that if we're talking about folks who have access to accounts, it's even broader than disclosure of the signers. By virtue of being a signer on a bank account, you automatically have access to that bank account. So the regulation absolutely encompasses the signers and likely would encompass an additional group of individuals. So I just want to flag that a broad group of folks who could be required to be listed on the 410. And again, going back to the fraud risk concern, once you have the account number and all of that information regarding who's authorized to access in a single location, that is something that increases the risk for potential fraud and the ability of nefarious access to that information with putting it on the form. The second issue I just wanted to raise as we move forward with considering ways to revise this potential regulation and the discussion regarding redaction is that currently, and this actually came to light as we were working to submit our letter by the comment deadline, folks were kind of gathering different information and sort of learning about, processes that are currently in place for the bank account numbers that we are currently required to list on the 410. And, what we learned actually subsequent to the letter is that Secretary of State, while they ordinarily are redacting the bank account numbers when providing a copy of the 410, and that certainly is happening in the online version. When paper versions of the 410 are requested, all that an individual has to do is redacted copy of the 410 to actually gain access to the account information. So, someone forwarded me an email that was an example of that, where it was really easy to obtain the full 410 with the account. And so, again, I just want to raise as we go forward, considering, potential improvements to the presentation, that is a real concern. And the fact that that information is not being redacted or that you can request an unredacted version does not inspire a lot of confidence that this information is be protected in the manner that it needs to be to make sure that we're being protective of the accounts and the risk. Again, thank you for consideration of our comment letter and of these additional comments. We look forward to engaging with the Commission further on this regulation.
Thank you, Ms. Andrews. If I may, I actually have a follow-up question for you. You mentioned the recent information that wasn't in your letter about the Secretary of State actually allowing members of the public to obtain unredacted copies that contain account information, et cetera. What if any, efforts have CPAA undergone to try and get the Secretary of State and other filing officers to adopt their regulations to prevent that from happening?
That's a good question, Chairman. I'm not aware of efforts. I would frankly have to look back to when the regulation was passed that required disclosure of the bank account number. I think that was in like 2012 or 2013, and I don't offhand know of kind of what the efforts were that we made at that time. I'm not aware of any recent efforts, but it certainly is, as kind of the discussion at this meeting has focused on, sort of the regulatory process of these agencies that actually have responsibility for maintaining the information. It certainly is a thought, in terms of able to make to engage on this particular issue with respect to, redacting information and maybe including a regulatory.
I appreciate that. I was certainly not aware that that was Secretary of State's. So appreciate you bringing that to our attention. Do we have any other public?
Yes, Commissioners, this is Jim Sutton from the Sutton Law Firm. It's just a quick comment.
Please.
My understanding is that the enforcement staff is pursuing this regulation for circumstances where the person who, maybe the principal officer of a committee or the treasurer, is kind of not available, not being responsive, and that's certainly a valid concern. But that concern is not really valid when the treasurer is one of the political law firms, such as ours, members of CPA, or one of the professional treasury firms. And for instance, on several of the committees that we act as treasurer or legal counsel on, we will have multiple attorneys technically being signers on them, just in case of, attorneys being out of the office or what the case might be. And it seems like if the bank account is being handled by a professional law firm or treasury firm, that this regulation is not really necessary, because the enforcement staff can always get a hold of that law firm or the treasury firm and will get the information from them, so that maybe there could be an exception to the regulation that if the bank account is being managed by a firm, it's not necessary for the firm to list out every single person at the firm who are technically signers on the account.
Thank you, Mr. Sutton. Ms. Green, I'm curious, do you have any feedback on that? And in particular, I'm curious, when we talk about the kind of the origins of the problem we're trying to solve here, has that come up in the context where, as Mr. Sutton points out, you have a firm administering the committees, or not?
I would defer to our auditing chief if she's aware of those circumstances.
Generally, if we have a firm who we are in contact with, we haven't had this issue, as was mentioned in the comment. But if it's otherwise, then we have run into multiple issues where, it's hard to get a hold of individuals that we are trying to figure out who the correct person is in order to obtain the bank statements.
Well, I think I would add that to the list then of things for staff to take a look at between now, when this comes back for adoption, whether such an exception could be included without doing harm to the ultimate policy objective we're trying to accomplish, which you articulated at the beginning.
Yeah, I mean, this proposed change regarding law firms makes sense. But my question is there any indication in the past that even when a law firm was serving as the treasurer, that we ever had any problems reaching that firm? Is there any indication that that's been a problem?
I am not aware of any. May have been before my time since I've joined, but I can certainly look into that and get back to you on that.
Right. Yeah, on the surface, the proposed tweak of this regulation makes sense, but just curious. Thank you.
Any more? Bainbridge.
I think Mr. Sutton has a good point in terms of definitely his law firm, which is well known throughout the state for doing this, and there's a handful of others, and there's known treasurers. I think where we may run into trouble is maybe some smaller outfits, or you have someone at the local level who's a CPA and works at a CPA, has their own CPA and they're doing this, but they don't necessarily do it full time. Those people can disappear more often than Mr. Sutton's firm is going to disappear. So I think if there's, I understand the point of maybe considering it, but I think the better approach would be what Commissioner Baker had suggested, which is maybe limiting the number of people that have to be listed, as opposed to creating an exception for certain types of entities. So just my 2 cents, that's probably, rather than come back and say that in 2 months, I thought I'd say it now in case there's additional direction from the commission on which way to go with that.
Right. Well, for my part, I think Mr. Sutton identified, it sounds like we don't disagree that Mr. Sutton has a good point, as you acknowledged, and so there may be multiple ways to accommodate that point, and so for my part, I trust staff over the next month or two to put pen to paper and try and do that. Mr. Wood, anything you wish to add? All right, any further public comment on this point? Hearing and seeing none.
It looks like we have one online. Like me to read it?
We do. We have one online comment, so folks can follow along with the online comments on our website. All right, Ms. Green, we will see you back in 2 months then.
All right,
Thank you very much. Thank you, Chief Shaw.
Thank you.
We'll now proceed to item 6. This is our pre-notice discussion of proposed amendments to Regulation 18531.5, having to do with recall elections. And with us is our Senior Commission Counsel, Erica Boyd. Good morning, Ms. Boyd.
Good morning, Chair and Commissioners. Erica Boyd, Legal Division. We had a little bit of a IT issue, so IT is going to help run my slides later when they come up. Based on the length of the memo, this should take about 5 minutes. We'll get right to it. This is pre-notice discussion of the proposed amendments to Regulation 18531.5 pertaining to recall elections. This is generally in response to questions that came up in 2021 in regard to both gubernatorial and local recalls. We are addressing the narrow issue here of clarifying the reporting requirements for recall elections, not the entire recall process outside of our jurisdiction. And we also wanted to point out that we're not breaking a lot of new ground here. Essentially, we're taking advice that has been given in prior instances and codifying it into the regulation, and we're also trying to take analogous situations and fit it into the recall sphere that doesn't fit squarely into either the ballot measure or candidate election box. So keep in mind, not a lot of new ground there. Also, a couple definitions to keep in mind as we get started. A recall is technically a measure under the Act. So it is akin to a ballot measure in that it qualifies for the ballot via a signature process. And also that the definition of a candidate is quite broad under the Act. So it's much more than what we think of typically when you think of someone running for office as a candidate. Under the Act, a candidate is someone who has qualified to have their name on the ballot or to have their name written in on the ballot, someone who has made an expenditure or received a contribution with an eye towards bringing that about, and also an elected officer, including someone who's the subject of a recall. Additionally, you retain your status as a candidate until you terminate your filing under the Act. So if you're a candidate in office, if you're an office holder, you leave office, you have no intention of running again, but you still have a campaign committee open, you are still a candidate for purposes of the Act because you have not terminated your filing requirements at that time. So on a recall ballot, it's a hybrid situation that we don't see in others, where you have the first question is, should the elected official be removed from office? So this is the ballot measure question. It's a straight up or down question, yes or no. Yes, on the recall, the office holder is removed from office. No, on the recall, they retain their office. I'm going to use the term target officer for the person who's the subject of the recall. Notably, they are not a candidate on the ballot. They are already elected to the office that they hold. The question is whether they are being removed from that office. Then the second portion of a recall ballot is the replacement candidate section. And so if the recall succeeds, then a replacement candidate is elected to fill that vacancy. Prior to 1994, this was actually held in 2 separate elections in California, and then in 1994, a constitutional amendment was passed to consolidate this into one, both so that you cut down and have more efficiency in holding just a single election as opposed to 2 separate elections, and also that you don't have a potential vacancy in the office either. So in the Constitution and other state laws, it's the target office holder is not a candidate, and they also cannot be a replacement candidate on that same ballot. The Act also specifically allows the target office holder to set up a separate controlled committee to oppose the recall, which we think of as a ballot measure committee, not a campaign committee, and it is not subject to limits. So given this hybrid nature and the fact that it doesn't come up as much as our other elections, when they actually do come up, there are understandably many, many questions that we get, both from target officers, replacement candidates, local filing officers, state filing officers, those trying to help them, members of the public, everyone. So really our hope here is to provide some clarity and to let everyone know the advice we have provided to others so that they can have that moving forward and so that everybody's on the same playing field. That said, we don't think that, everything we're going to do here is going to make this a completely clear and crystal and everyone can go forward, but we would love to hear feedback from others as well if there's other things that we haven't touched upon, especially from local filing officers. If they're seeing questions come up repeatedly that we could address, that would be really helpful to know. So please reach out. To briefly cover the proposed regulatory changes we'll go through today, we're going to specify that the voluntary expenditure ceiling limit for a general election applies to a state recall replacement candidate. Clarify that pre-election reports and late contribution reports are not required for a target officer's other controlled committees by virtue of the recall being on the ballot. Clarify that a target officer of a recall is not required to file a candidate statement of economic interest. Address termination requirements for target officer recall committees, and clarify which disclosures are required on recall and replacement candidate advertisements. Separate from that, we also have a proposed legislative amendment which concerns which expenditures count toward the voluntary expenditure ceiling. This is more broad in nature and applies to all state candidates in that sense, not just recall elections, and we are proposing a legislative amendment in that one and not a regulatory amendment at this time. So if we could start on the slides. Thank you. Okay. So starting off with the issue of the voluntary expenditure ceiling limit for state replacement candidates. During the gubernatorial election, we had a replacement candidate ask whether the primary election, or the general election limit applied. Section 85-400 specifies the voluntary expenditure ceiling for state candidates. This is a lower limit that's set for the primary. There's a higher limit set for the general. If a candidate accepts the limit, they're able to purchase space for a candidate statement in the ballot pamphlet. So this could be a huge benefit to a candidate. It's going out to every voter in the state of California. It's going to be online as well. So that would be the impetus for accepting the voluntary expenditure limit. This isn't a voluntary limit. They do not have to accept it, but if they do, they get to purchase the space. So the regulation currently specifies that replacement candidates are subject to the voluntary expenditure limits, but doesn't specify which limit applies, the primary or the general. So in this instance, we advise that the general limit applies, reasoning that in a recall election, it's a single election, there's no runoff, there's no second election, this is more akin to a general election, and so we decided that was the limit that should be applicable here. We also look back at advice that was given in 2003, and the higher general limit was used at that time as well. So this is just adding language to the regulations specifying that it would be the general limit going forward. Any questions on that one? Go to the next one. Okay, so target officer pre-election reports and late contribution reports. For candidates with multiple controlled committees, they file reports for all of their controlled committees on the same time they would file any pre-election reports for a committee for office. So if a candidate is on the ballot in November 2022 and they have a separate ballot measure committee, they will file pre-election reports for the ballot measure committee at the same time they're filing pre-election reports for their campaign committee for office in November 2022. This is based on the current pre-election reporting in the statute and regulations. The opposite is not. So if a candidate has a ballot measure committee that's primarily formed for a measure that's going to be on the ballot in November 2022, they do not have to file all of their campaign committees at the same time they would file their ballot measure committee, because it's not currently required in statute. So we received a question as to whether a target officer had to file pre-election reports for all of their other control committees at the same time their recall committee would file. And we advised that no, they did not, based on our reading of the statute and current regulations. And this would be the same for late contribution reports as well. When someone is on the ballot within 90 days prior to when they're going to be up for election, if they receive contribution aggregating to $1,000 or more, you file a report within 24 hours. So if the person is on the ballot in 2022, but they also receive a contribution to a separate ballot measure committee, that ballot measure committee also has to file a late contribution report. And again, the opposite is not true. So if their ballot measure is on the ballot, but they are not up for election, those other committees will not be filing late contribution reports. This would be the same as if we were advising on an office holder that had a primarily formed ballot measure committee, and that ballot was going to be was up for election, and their other campaign committees were not. This is the same advice we would give in that situation. So again, it's just adding this advice to the regulation so that it's clear for all of those trying to file their reports correctly. Also, one thing to keep in mind is that typically when someone is up for election, we're looking at the activity to their other campaign committees in an effort to see whether someone's giving to multiple committees to try to influence them, perhaps, with the thinking being that their election committee is subject to limits, right? So you can only give a certain amount to this election committee, a certain amount to this election committee. With a ballot measure committee, though, and with the target officer recall committee, there's no limits. So if someone's trying to help that person in the recall, they're going to give as much as they can straight to the recall committee. There's no benefit in giving to one of the other target officer committees to assist with the recall. So we wanted to point that out too, because I think it's a substantial difference as opposed to someone taking contributions into a committee that's subject to limits. We can go to the next slide. So this is the actual, the statute and the regulation, talking about pre-election reports and filings for candidates with multiple committees. If you could go to the next one. Here's a chart where I tried to lay it out a little more simply. So the target officer facing a recall has a ballot measure going to be up in 2022. They also have a 2024 campaign committee and another ballot measure committee. So the only committee filing pre-election reports in regard to the recall is going to be their recall ballot measure committee. Conversely, a replacement candidate for the recall who is up for election at the 2022 recall also has a 2024 campaign committee and another ballot measure committee. All of their committees will be filing pre-election reports on the same timeline as their 2022 election committee and late contribution reports. Okay.
And so if one were to look at this slide, looks like there's disparate treatment between the replacement candidate and the target officer, like if you look at it on its face. But if I'm understanding you, that disparate treatment in terms of what reports need to be filed springs from the constitutional provision, which clearly says that a target officer is not a candidate. So it's really apples and oranges in that sense. And the statutory language as well, right? So it's not, we're not creating a rule that is treating people differently. We're creating a rule that recognizes that a target officer is different than a candidate under existing law.
Yes, both stemming from the Constitution and from the statute saying that a candidate files pre-election reports when they're up for election, and their control committees do as well. It does not specify that they file them when their ballot measure committee is having a measure that's up.
Commissioner Baker?
Thank you. That's a great point. I appreciate the chair making it, because I'm really grappling with this particular one. And it's both in part, your memo mentions that recall situation is a hybrid. It doesn't quite fit into things, and we're trying as best we can to be consistent and follow the law. So this definition of a candidate. So I'm understanding, if I'm hearing you correctly, that it's the state constitution that says on the second question, the question of who's going to replace you, the targeted officer is not a candidate.
Correct.
And that's the language that I saw in the Constitution. It's with respect to that second part of a recall ballot experience. The first question, which is the ballot measure, it's treated like a ballot measure, shall this person remain in office? Is the Constitution isn't saying either way if the target officer is a candidate for purposes of that, because it's treated as a ballot measure. I'm trying to make sure I have that correct. That first question is, when we say the Constitution says that the target officer is not a candidate, it's for the second question. They're not going to appear on the ballot. Does the Constitution say in any other way that you're not a candidate?
It specifically says they can't be a replacement candidate, which to me implies that the first question on the ballot is not a candidate election.
Okay.
It's the second question.
Yeah, and for me, when I was reading that, it really is going to the second question. And why I'm dwelling on it is because the recall is a different situation, and effectively, that first question is about, should this person be in this office? Kind of like being a candidate, right? You have a particular person, a particular office, but the law, I understand the statute and the Constitution treats it as a ballot measure. And much of the reasoning behind this disparate, what appears to be disparate treatment, but is consistent with the law, as the chair mentions, is that this person is a candidate, so therefore they aren't going to be treated that they're not a candidate, so they're not going to be treated that way. That's what I'm hung up on, because recalls are different.
Right.
And if the Constitution gives us the ability to require that these statements, the pre-election disclosures, for the first question, for the opposing the recall question, if we have the ability to require that they be filed. From my part, I'm still reading that the Constitution doesn't prohibit us from requiring that, because the Constitution's addressing the person is not a candidate for the second question. Can't be a replacement candidate. But on that first one, it's a ballot measure, but do we have the authority to require anyway that they file those pre-election reports, because to be a little bit more consistent with how it looks, and also for the practicality of it, which is during an election, money is being spent and being given. And so that's my first question. It took me a long time to get there, which sometimes it does, but this is a bit of a complex issue. So do we have the authority to require that the target officer ballot measure to oppose the recall file these forms?
That would require a statutory change. Right now, the pre-election reporting requirements that we're going from, if we can go back one slide, please. Under 84200.5.
Okay.
So the requirement for candidates that are up for election is coming from under A1. So all candidates appearing on the ballot at the next election and their controlled committees. So that's what the requirement for candidates up for election and all of their controlled committees to file pre-election reports. If that was changed, or if there was another section added saying that anyone who had a candidate-controlled ballot measure committee that has a measure up at the next election shall also file reports with all their controlled committees, I think that might change our interpretation there. But given the current wording of the statute, I don't think there is a way for us to get to requiring the target office holder to file pre-election reports here.
Okay. Because I'm of the mind that we follow the statute and the Constitution. We don't make it up on our own, even though we want to. And I want to require that they be filed.
It feels a bit different, and like you said, it doesn't fit squarely into any nice box that we have, and so it feels a bit, unwieldy.
So I don't want to put words in your mouth, but am I correct that the reason why we can't do it isn't the Constitution saying that the target officer is not a candidate? I'm putting my hands over here because I'm seeing an imaginary ballot over here. But it's because the statute is saying when these things are required, and saying it's all candidates in these situations. It's not the Constitution.
I will give you a tentative yes on that.
Well, that's helpful to know. And of course, this is pre-notice, so if you feel the need to revise those thoughts, thank you. Thanks. I mean, it means a lot to where these go, because even if we wanted to do it, it's important to understand what's the statutory issue and what's the constitutional one. So thank you for that.
Of course.
Follow-up question.
Sure.
I think my understanding is that a recall candidate who has a no on the recall, a target officer who has a no on the recall committee, that committee, you said, is not subject to candidate contribution limits.
Correct.
Why is that?
And 85315. I believe it's 85315 is the provisions that allows the target office holder to set up a separate committee, and it specifically says that that committee is not subject to limits and all.
Do you have an understanding why, if that's a statute, why does the statute provide for that?
my understanding is the intention being that they are not a candidate, and it is a measure, a recall is a measure. So therefore, if they have a committee set up to oppose the recall, it is a measure committee, which does not have limits like a candidate election committee would.
And just kind of the technical question, when the changes were made in the mid-1990s, the answer might be in some of that legislative history, just an assumption, but.
You know, I looked for some of that online and was not able to find it, so I'll need to do a deeper dive at the library, so.
And what's a library, right?
I know. Are they open these days? I don't know.
All right.
Anything on that one?
Commissioner Wood, I can't see you, unfortunately, on my screen right now, so I don't know if you would like to ask a question, but if you do on this point, please do.
Thank you for checking in. I am just really impressed with how straight everybody's keeping all these different sections and the difference between the Constitution and the statutory requirements and all that. And so I'm just really enjoying that everyone's raising all this, but I don't have anything to add right now.
All right, Ms. Boyd, please continue.
Same vein. Received a question as to whether a target officer files a statement of economic interest. Statement of economic interest is something that a candidate files when they are filing their declaration of candidacy. This can disclose things such as their income, any property, reportable property they may have, other sources of income to them, stocks held. And really this is so that the public is aware of any potential conflicts that person may have and to help ensure that the officer isn't making any decisions which would enhance their personal finances. So when a candidate files their declaration of candidacy, they're also required to file a candidate SEI. I'll refer to it as an SEI. You go to the next slide, please. So the confusion arises because in 87201, which talks about candidate SEIs, it says every candidate would file this. And so as we talked about earlier, the definition of candidate is quite broad and very specifically includes the subject of a recall. But when you read every candidate for an office specified in section 87200, and 87200 includes all the state offices and various local offices. So really what this is getting at is that people that are up for office at the time of an election, not every candidate under the larger definition of a candidate. And as we stated before, we are very explicit that the target officer is not a candidate on the ballot at a recall. The replacement candidates are the ones who are filing a candidate SEI when they file their declaration of candidacy. The regulation already specifies that a target officer does not have to file a new statement of intention to be a candidate, but the replacement candidates do, and so we are adding language here. If you could go back one slide now. We are adding language to say that the target officer does not file a candidate SEI, but the replacement candidates do, in fact, file one of those. One thing to keep in mind here is that the target officer would have filed a candidate SEI when they were running for the office they were currently elected to. They would also file an assuming office statement potentially and then annual statements thereafter. So we don't think that the target officer in any way is avoiding kind of reporting in this situation. And also keep in mind that really, you know, this is to publicize their financial interests. But if they took a decision or made a decision at any time that enhanced their financial interests, they would be subject, it would be a violation of the act and they would be subject to potential action because of that. So them not filing this at that time is, you know, they've already done the filings leading up to this point, and so we don't think that there's any gap in disclosure. On that. So again, we are adding that they would not be filing one, and we are specifying under the replacement candidate section that they are filing a statement of economic interest.
I think in your answer it was pretty clear, but it's clear, at least from my standpoint, that a targeted officer has been a candidate and has been filing in accordance with the act throughout his or her tenure. In the case of a recall or a replacement candidate, you could have a replacement candidate who has never been a candidate for office and never been subject to the act by filing forms or any other, you know, requirements, you know, under the act. Would that be correct?
Yes, that's
Okay.
Actually a great point to make, and I think
Okay.
that's, yeah, why the requirement is there for candidates filing one, because we do have a lot of people, especially at the local level, I would think people running for office for the first time that have never been in office. So that really would be the first disclosure of their finances that the public would know about, as opposed to, you know, a recall officer that has been, target officer, subject to a recall, that has been filing annually since they were elected.
Thank you.
Yeah.
Continue.
Okay. Now we're looking at a target officer recall committee termination. So section 85315 provides, and I'm going to read this, after the failure of a recall petition or after the recall election, the committee formed by the officer shall wind down its activities and dissolve. Any remaining funds shall be treated as surplus and shall be expended within 30 days after the failure of the petition or the recall for specified purposes, what you can use surplus funds for. So we received a question from a recall committee asking if they could stay open longer than 30 days to receive refunds and pay outstanding invoices. We granted this limited request. One reading is that the 30 days applies to complete dissolution of the committee. We think this is wholly impractical to do. Speaking from experience, 30 days to close out the smallest, cleanest committee would be hard pressed to do. To close out a larger committee would be impossible. And the 30 days is in the sentence that pertains to the remaining funds on hand. So we also are reading this in conjunction with section 84214, which permits the commission to adopt regulations regarding termination of committees. And really the aim there is we want committees to have their activity fully done and sewn up before a committee terminates, because if there's anything that is happening afterwards, the public may need to know about it. So if they're getting refunds, if they're paying invoices still, that should actually be things going on reports that the public is able to see before they close out and terminate. So in relation to that, we recommend specifying that the recall committee can remain open for more than 30 days to receive refunds from vendors and other government entities, pay costs associated with winding down the committee, such as tax preparation, audit compliance, campaign reports, and any other outstanding invoices they may have at the time.
Thank you. This is definitely a very practical one to do. And as you mentioned, that last point is in making sure that there's still transparency to the additional transactions that are going on after the recall election itself. Is it possible to have, say, you can stay open for 90 days? I'm kind of thinking of when a candidate doesn't win re-election, they have a certain period of time by which they either need to move funds over into maybe a new committee,
right,
or they become surplus, or they have to do something with it.
Right.
And have you put thought into if we want to borrow that similar language and time frame and put it in the same context, so there's some certainty, it's not totally open-ended?
We did. We went back and forth on that. We looked at, 90 days, 6 months, 24 months. Right now, we left it open-ended, but welcome to hearing feedback from, obviously, commissioners and members of the public as to if we think there's a timeline that would make sense in this situation. We could also potentially look at adding this to the regulation, which would permit a committee to reopen at a later time if need be, in order to, sometimes a committee can seek permission from the executive director to reopen if they need to receive a refund and disclose it and then close out again. Obviously, we want to be as efficient as possible and allow them to stay open long enough to do everything they need to do to close it out completely, but we're open to that. So if we hear feedback that we think that would be useful, we're open to adding that.
Thank you. If I may, I do think the 30 days is just not practical for the reasons you said, but I would, when this comes back to us, for my part, I think it is good to have a certainty time frame, both for consistency and something that's not totally open-ended. Like, I'm not sure what the argument is for keeping it completely open-ended, and I would incline to see it that way.
There are other types of committees that are standard that you're proposing here, where they could remain open essentially indefinitely for limited purposes?
Ballot measure committees under the current statute and regulations do not have a timeline for closing out. They are pretty open-ended. They can do what they need to. Candidate committees need to completely close out within 24 months of the person being defeated or leaving office. So that's a pretty long off-ramp as well. So 24 months is one of the ones we were contemplating.
So the approach you're taking here is consistent with how we treat other ballot measure committees, because we, under the law, treat target officer recall committees like ballot measure committees. We're just making it consistent with what we already do. Any other questions?
Last, in terms of our proposed amendments, this is in regard to advertisements by target and replacement candidates. We received a question as to whether an ad by a replacement candidate that also addressed the recall needed to have both a candidate and ballot measure disclosure on it. And just for informational purposes, there are different disclosures required for candidate ads versus ballot measure ads, and they also differ depending on who is paying for the ad. So it could be multiple different disclosures that would have to go on a single ad if we decided to go that route of having both of them. We determined instead that a replacement candidate only needed to include the candidate disclaimer for a couple different reasons. First, the disclaimer provisions don't squarely address this situation. It likely wasn't anticipated at the time, and we thought it unfair to impose additional disclosure requirements given a lack of clarity in that regard. Second, a candidate is able to do ads against their opponent without having a different type of disclaimer. It's not considered an IE or a contribution. And so we're reasoning here that in this instance, it's more akin to that of a candidate supporting the recall is really helping support their own candidacy, right? They want the person to be recalled so that they can be elected. And also, this is historically how we've treated ads paid for by a candidate committee that also mentioned a ballot measure. This partly stems from the definition of contribution in 18215C15. It excludes a payment made by a candidate for a communication in support or opposition to a ballot measure if the communication features the endorsing candidate or clearly identifies them as the sponsor of the communication. So I believe the thinking there is that it is clear who is paying for this ad if it's the candidate that is featured in the ad saying, you know, vote for me and vote yes on Measure F, that it won't be unclear to the public who that's being paid for by. We're adding sections related to other entities paying for ads as well. This is not any new advice, it's just putting it all in one area so that everybody can have access to it. And hopefully it'll provide some clarity in the area of disclaimers and disclosure.
I have a very basic question. In terms of the content of these advertisement disclosures, disclaimers, is there information that, for example, when you say that it's going to be the disclaimer that is required for the candidate's own campaign, what's the difference between the type of information that would be contained in that disclaimer versus one that is required for a ballot measure committee?
So this question came up specifically in regard to a yard sign, so I pulled the yard sign to use as an example in this. So in a replacement candidate situation, a yard sign for a candidate's own election actually doesn't have a disclaimer. There are very few instances within the Disclose Act, but there are a couple under a candidate's own campaign where they don't have disclaimers. So these are things like flyers, door hangers, no disclosure. But things such as mass mailings, calls, radio, TV, there's disclosures required on all of those. So in this limited instance, if a replacement candidate was doing a yard sign that said, yes on me, yes on the recall, there would not be any disclosure required on that yard sign. Target officer, instead, for a yard sign would need to have ad paid for by in the committee name and the major funders, and also a primarily formed committee doing an IE in support of the recall. If they're doing a yard sign, would also have to have ad paid for by committee name and then the major funders as well.
In this context, when we're talking about disclaimers, the requirements for the target officer and the required disclaimer is actually greater than what would apply to the replacement candidate?
Yes.
Thank you. Good question.
All right, so that's our proposed regulatory amendments. Finally, coming to our proposed legislative amendment.
Sorry, I'm sorry. Can I interrupt before we move on? Since you can't see me. Yeah, sorry. So this, whenever we have these, I mean, disparate, such a technical legal word, but whenever we have the target officer being treated differently from the candidate who's running against the target officer, and that's created by a kind of gap in the statute, would that make sense for us to ask the legislature to fix it?
Well, I think that is something that if the commission wanted to do that, I'm sure we could do that. My understanding is that the legislature recently looked at potential changes to the recall statutes, and it's my understanding they have not proposed anything substantive. Commissioner Baker, I don't know if you have further.
I don't have secret insight of any kind on it, but that's correct. There was a sort of a more informational hearings on the issue. Members have introduced things, but there's nothing that I think is going to head for the governor's desk that's still alive at this stage. So there's a distinction there, but some individuals may have proposed changes, but they may not have happened. I appreciate Commissioner Wood's question very much, because I've already written down for future discussion that if we could, maybe it'll be in law and policy first, but usually in the fall we have conversations about what the legislative priorities will be. I would be grateful if that conversation can include some of the questions that have arisen here, not just the particular ones we're pointing out, but like the ones I pointed out earlier. So thank you, Commissioner Wood. And so yes, the legislature has had hearings on it. They were, there's no bills that came about later.
Thanks.
Any additional questions, comments? Ms. Boyd?
Last one, let's go to the last one. Okay, so for our legislative amendment, currently costs associated with preparing and filing campaign finance reports do not count against the voluntary expenditure limit. Some other things that don't are contributions to other candidates or committees, filing fees, ballot pamphlet statements. The regulation mirrors language that was in the statute when it was adopted in 2001. So these costs were excluded from counting against the limit at that time. In 2017, there were some various statutory changes that were made, and the exclusion, we believe, was inadvertently left out. We think it was a drafting error, not an intentional omission. And so we would recommend pursuing a legislative amendment in this instance instead of changing the advice that's been in place for the last 20 years and that we think is as well.
Any questions for Ms. Boyd on this point? Ms. Boyd? Thank you. That was an excellent presentation, a lot of information. And I think you did a very nice job actually distilling it down to a very understandable. Thank you. Do we have any public comment on this item? This is pre-notice, so we won't be taking action today, but do you have any public comment on this? Hearing and seeing none. Any final thoughts for Ms. Boyd?
Thank you for helping us through a complicated issue. I appreciate how clear you made it and the slides. Of course. We're visual people here, so it's helpful.
All right. Thank you, Ms. Boyd. We'll see you in a couple months.
Yes, thank you.
All right, let's go ahead and proceed to our next item. This is our pre-notice discussion of proposed regulation 18400, treasurer, assistant treasurer, responsible officer, and principal officer competency, or capacity, as I like to think of it. Welcome to the table, Senior Counsel, Ms. Harrison. Good morning.
Morning. It's still morning. Good morning, Chair Mandich and Commissioners. Karen Harrison, Senior Commission Counsel with the Legal Division, and I am presenting proposed Regulation 18400 for pre-notice discussion. This regulation responds to the Commission's request to address an issue that recently came to light through an enforcement matter where a minor served in the role of a treasurer for a campaign committee, and to also address similar issue of a minor serving in the role of an assistant treasurer, responsible officer, or principal officer. And unlike the previous presentation, this is a very simple proposed regulation, so I'll just read you the language. The proposed language in Regulation 18400 would state an individual must be a minimum 18 years of age to serve as a treasurer, assistant treasurer, responsible officer, or principal officer. And here are the reasons for this proposed language. The Act does not have express qualifications for these roles, and it doesn't expressly prohibit a minor from serving in these roles. However, these roles are very significant roles. They're public roles. They require the knowledge of campaign finance laws and rules. They require record retention. They require authorizing expenditures, and also verification under penalty of perjury on these submitted forms. So this is a very significant role in each one of these instances. Minors, by law, have a limited legal capacity, and this means that a minor is prohibited from making certain contracts and treated in a certain way under the law, and at best can make a contract that they can disallow. They can choose to say that that wasn't a correct contract that they made. So a minor has a particular limited legal capacity under the law. This considers a minor's ability to understand financial transactions, contractual agreements, wrongfulness of their actions, as well as the concern that a minor might be manipulated by an adult. If allowed to assume any of these roles, the Act's penalties for wrongful reporting or the statement verification would likely be unenforceable. For these reasons, regulatory prohibition on minors serving in these roles is necessary to ensure two really important purposes of the Act, and that's the effective campaign finance reporting disclosures and the effective enforcement of the Act. So following the Commission's direction today, we will bring the proposed regulation back for adoption at a subsequent meeting. And right now, I'd just like to ask if there are any questions.
Thank you, Ms. Harrison. Appreciate your work on this. And as you point out, this regulatory idea really sprang from a recent experience we had with in enforcement.
Correct.
And a concern, a valid concern, that if we didn't close this loophole that has now become apparent to us, then people could evade enforcement of the Act entirely by having people under the age of 18 sign on as treasurer, assistant treasurer, et cetera. I mean, it's kind of like, as you pointed out, the law clearly, in many contexts, considers somebody under the age of 18 as not having the capacity to serve, to enter into a contract or to engage in certain activities. So it's kind of, in my mind, this is very straightforward. This is first-year law school stuff. You know, 14-year-olds can't enter into a contract like that. So appreciate your work on this. It's straightforward. And the one thing I guess I would point out is I know there's some concern that we want to encourage young people to get involved in campaigns. And I think that is a good thing that young folks do get involved. Nothing in this regulation, though, prevents somebody's 14-year-old nephew from volunteering for a campaign. It's simply that they cannot sign and file the campaign reports that the law requires or otherwise be held accountable in an enforcement action, right? I mean, they can still volunteer.
That's correct.
Okay, I just wanted to make sure we clarified that. Appreciate it.
Yes, thank you, Senior Counsel Harrison, for your presentation. And this is a serious matter; otherwise, it would be comical. But to expand on what the chair commented on, a minor can't vote, but without this regulation, they could serve as a treasurer of a campaign committee.
That's correct.
So, and then I have one quick question: what would given this regulatory prohibition about a minor serving as a treasurer? What if a campaign committee just ignored this regulation once it went into effect? What could be the potential fine or penalty that could be imposed on a campaign committee, if any?
Well, I might defer to enforcement to answer that question since I don't usually delve in the enforcement side of things. But I would just point out that it's mandatory that a committee have a treasurer in place in order to function. They can't accept campaign contributions. They can't make expenditures. And so in this instance, with this regulation, I believe that they would not have a legitimate treasurer in place. And so that would bring the full enforcement powers to bear, that committee is basically invalid and not able to operate. But if enforcement has any other comments, they're welcome to do so.
It was just a general question. I mean, it's a logical answer that makes sense, but this regulation didn't stem from a logical scenario, so thank you.
Any other questions or comments of Ms. Harrison on this regulation? Is there any public comment on this item? This is item 7. All right. With that, thank you very much, Ms. Harrison. We'll see you in a few months. Unless there's an objection, why don't we take a 10-minute comfort break and well, a little more than 10 minutes. Why don't we reconvene at 11:40? So 13-minute comfort break. All right, we'll go ahead and reconvene now, and we are on item number 8. This is an update on political reform education program, and with us today is Chloe Hackert, our Manager of Education and External Affairs. Good morning.
Make sure this is on. Good morning, Chair and Commissioners. We are here today to give an update on the Political Reform Education Program, PREP. And with me today is Dominika, and I'm going to let her introduce herself.
Dominika Łudzińska, PREP Manager.
Good morning.
Okay, so now I'm going to share my screen. I have a quick presentation for you guys. I cannot share my screen. Alrighty, so we're going to begin with an update on the PREP program. So we officially launched on June 6th. The first and only course we have launched at this time is the Statements of Economic Interest course. The last presentation on PREP in February gave an overview of the program, qualifications, exclusions, procedures, and the types of courses we intend to offer in the future. This is a quick update on our work over the past few months since February and on the launch of the first course on June 6th. Just to kind of some background from our first presentation, the idea of an educational program as an alternative to an enforcement penalty for minor violations of the Act has been talked about around the agency for over 20 years. So we're really excited to have this up and running now and to have our first course launched and have future courses on deck to be able to assist people in learning the rules instead of running through our enforcement program. In January 2021, at the direction of the Commission, amendments to Regulation 18360.1 were made, which provided for the creation of PREP. In November 2021, we hired Dominika, and then we shortly hired our political reform consultant, Sylvia Riveros, who created the content of the course, and we are now fully staffed with our staff services analyst, Edgar Ramirez, who's kind of running the day-to-day operations of the program and assisting all the people that are enrolled. So with that, we have a quick kind of update on what the procedure is. So the first step is that the Enforcement Division applies the criteria to check if the respondent qualifies for PREP. Once they qualify for PREP and they are referred over, PREP registers a new learner on the learning platform, which is Blackboard. The learner then will register for a course. Again, the only one offered at this time is Statements of Economic Interest, but in the future, more courses will be available for them to register for. Learners receive a certificate for completing the course after they complete all their requirements. And then once they have concluded the PREP requirements, the Enforcement Division closes out their case with a no action closure letter. So that's kind of the quick procedure on how the PREP kind of start to finish for PREP referrals. So we want to give an example of what the learner will see. So this is the login page that they will get when they begin and enroll in the course. Since the PREP team was hired, we've been working with our vendor Blackboard to create the program and the courses offered. So again, this is the login page that they see. Prior to our launch, the PREP team and our vendor worked very close together through an extensive testing process before we launched it. It was a team effort, so everyone from the legal division, the enforcement division, the SEI unit within our agency all reviewed the course content, our modules, the course to make sure that it was working and efficient. We had 9 people. We want to thank them for taking their time to take the course and give us their feedback. And they ranged from all levels of experience within the Act, from analysts to attorneys, in giving our feedback on the course testing. We requested each staff member to enroll and complete the course as if they were a learner, so that way we would know what hiccups we would need to change if there is anything in testing. So they went through everything that a member of the public would have to go through. We did receive positive feedback, and we found that on average it takes about 3 hours to complete the Statement of Economic Interest course. So we have our first set of learners enrolled. We have some that have already completed the program. We have people in flow to complete it hopefully within their 60 days. So we are hoping to get more people referred and enrolled through PREP. Now we're going to kind of give an example of what they will see as they continue on to the program. So this is the learner's dashboard. When the learner is enrolled in the course, they will see this dashboard to get an idea of what their progress is. So for active courses, I'm moving my cursor over it, it shows a progress bar of completion. because again, they have 60 days to complete the course in its entirety, so it's good for them to know where they're at in that process, how close they are to concluding, to time that to make sure they complete within that 60 days in order to be having a prep completion and their case closed with no action. Otherwise, they would go back to enforcement and likely be resolved through that streamlined program. Once they complete the course, on the right-hand side, they will have a notice that they completed the course. And then for pending courses at the bottom, that's for when they have selected to enroll in the course, and then the prep team needs to approve it. This is for when the time comes that we have multiple courses. They may have accidentally chosen campaign. You were referred for SEI. We're denying this one. You need to re-enroll in the Statement of Economic Interest course. But this is their dashboard, so this helps them understand exactly where they're at, what courses they're in, and how much they need to complete. Now we go on to the welcome page. So once they're in that Statement of Economic Interest course, this is what they will see. The navigation is really easy on the left-hand side. They, again, have to take learning modules, and then they take a final test and give a survey, and then they can have access to that dashboard again for their progress to see where they're at. So this is what they'll see every time they log in to their course, and then they can self-assess on, it will show their progress where they've completed, let's say, Module 2, now they're on Module 3, and they can go right into there. We find that it's very helpful to kind of have that navigation bar for them. So we'll go a little bit more into detail on the learning modules themselves. So the course for SEI consists of 5 separate learning modules. Learners will be required to pass a test after each module in order to move on to the next one. Once the learner completes all 5 of those learning modules, they must then complete and pass a final test at the conclusion of the program. That goes over all the knowledge that they incurred during those 5 modules. Finally, the learner will also complete a survey for feedback on their experience with prep. We will be maintaining all of those survey answers for all the completed courses. We are looking forward to receiving that feedback from our first set of enrolled learners to make the program improvements, and for when we start launching other courses to know what feedback is needed and what we need to change. All of that we're really excited by. So as you can see here, there's a yellow box for the learning module presentation that we're going to show on the next slide. So each module is a video with animations describing the reporting and filing requirements under the Act, specifically for statements of economic interest in this module. Each video is between 20 and 30 minutes, and we want to give a shout out to our communications director, J.Y. Renga, who kindly recorded all the audio for our presentation course. So learners will be pleased to listen to such a smooth voice as they take the course. Maybe be, okay, if it's 20, 30 minutes, I can live with this. I would much rather have it than mine. So we're very thankful for him for lending his voice to that. So this is what the learners will be taking as they have the module. Then at the conclusion, they're going to take a test. On the next slide, we have an example of what a learning module test will look like for them. So after reviewing that presentation and the module, they have access to the learning module test that they must pass in order to go on to the next learning module. Learners must answer 75 to 80% of the questions correctly in order to pass the test, and they will not be able to begin the next learning module unless they have passed. But there is no limit. They can take the test as many times as they need to. It's an open book. They can look at resources on our website, go back to the module. The goal is for them to learn. So while they have to pass the test in order to move on to the next module, they can take as many times as they need and look at resources to be able to pass that test. There are different types of questions in each type of module that range from true, false, matching, multiple answer, and they kind of vary each time. So there's a little bit of difference in each one, but again, they just have to pass a small little test at the end, and then they have a big test at the very end for when they have to conclude the course. But after submitting a test, if they do get things wrong, and if they possibly did fail, they receive feedback. So they're going to know which ones they got incorrect. We don't give them the answer on what the answer should be, but we do let them know that this was incorrect, and if they need to retake it, exactly what questions they got wrong, to look at the learning module again to understand what they failed to understand the first time to get the answer correct the second time. And again, they can retake it as many times as they need. So this is what the learning module test looks like if they are to take it. And then, once they do conclude the program successfully and have passed all their module tests, passed the final test, they will receive a certificate. The certificate is the proof of completion, acknowledging that they completed the course, and again, it has the FPPC case number from the referral from enforcement, the prep number for our records, and the issue date. So that is sent over to them. They have that in their dashboard. They have a copy of it. It's also sent over to the Enforcement Division, and then they will close out their case with a no action closure letter. So that's pretty much it. We just wanted to give some future updates as well. So right now, the Statement of Economic Interest course is the only one offered and being offered for free. The next course we are launching is a local campaign course. So we're really excited by that, and that's what we have on deck next. And that's it. So please let me know if you have any questions.
Thank you very much. Excellent work on getting this up and running. I mean, as you pointed out, this is an idea that's been out there for a while, and thanks to your hard work, both of you guys, we now have this and we're offering it. And I think this is a great way to help improve compliance with the Act. What is your timeline like in terms of the next module that'll be available? I think you mentioned the local filing. So what's our anticipated timeline on that?
We're currently working on it. We think easily we'll have it done before the end of the year. We want to have it timed out with the upcoming November election. Enforcement Division does pre-election outreach and things like that we think this would be a good way for any candidates that made minor violations with this upcoming election. There's probably, well, at least I can say from my trainings that I've been hosting, there seems to be a lot of interest in this election, a lot of first-time candidates. There might be people that make accidental minor violations, and we'd love to be able to offer prep to them at the conclusion of this election if they did make those mistakes.
Great. Thank you very much. Do we have other questions or comments?
Thank you. So, first of all, I think it's great that Jay Wyringa's voice is going to be voiced. So that alone is a reason to take it. But a couple of quick ones. I may have had some experience with tests like this in the speeding ticket realm. And one of the things that I was curious about, you mentioned that you identify which questions were wrong. Do you identify which module to go hunt down, like point them in the right direction, and can the person get to that quickly? Do they have to start over and then know to look in that module? How easy are we making it for them to do their own due diligence to track down the right answer?
You want to take this one?
Sure. So we try to make it as easy as possible for them to learn. So if they get something wrong, they get information which module and which slide they should go to get the right answer.
Great. Yeah, because this isn't meant to be a, whipping post or something, so great. In addition, once the person has completed the course and has the certificate, what's the time frame by which the no action letter and no action conclusion happens?
A week. I think 1 week.
1 week, okay. And is that almost an automatic point, automated to some point, or is a human in our office taking a look and confirming everything? Oh, it looks like it's for enforcement chief.
It's an enforcement part.
Thanks.
All right. Chief Brereton, you want to comment on that?
Yes. So our intake staff primarily so far have been the staff who are making the referrals. So when the learner completes the course, that certificate is sent to the same intake staff person who had made the referral, and then that intake staff person sends it to me to approve the no action closure, and then it goes out.
Okay, great. And that 1 week point is it's sort of a self-imposed. Like if we have a workload, it may be a little bit less, it may be a little bit more, but that's the time frame that we're looking at.
That's correct. And the letter that we send is a template, so it's very quick for the staff to be able to produce that letter and send it to me for approval. So it's not, most of our stuff so far has gone out with less than a week. We gave ourselves a week just in case, the election coming up, we wanted to make sure that we had a little bit of a buffer, but we want to get this wrapped up very quickly for these folks.
Great, yeah. Thank you.
Any other questions or comments for our prep team? Commissioner?
Yes. Commissioner Baker covered some of the questions that I have, but first of all, I want to commend Ms. Hackett and your team on all your hard work. You can see the level of detail that went into putting this together. It takes 5 minutes to read and countless hours to prepare. But my question goes more to someone, let's say someone completes the program and let's say they're diligent and they say, you know what, I want to brush up on what I learned in the prep program. Will they be able to go to the website to access information? Is there any way if somebody wanted to, engage in some form of continuing education, that they could do so?
I think they still have access to their course.
No.
No, yeah. So for prep, it's really, again, it's if you are enrolled and you make that criteria through the enforcement
Right.
and all that. But if they wanted to continue their education, we have a lot on our website. I'd be like, come over to us. We offer webinars on statements of economic interest filing. We have those slides on our website. We're continuously updating fact sheets and things like that. But if they wanted, basically at this time, prep is really offered to those that are being run through that enforcement channel as an alternative to that enforcement penalty. But if they wanted on their own volition to retake prep, that's something we haven't really contemplated at this time, but we do have other avenues for them to further their education on our website if they would so choose to do so.
Right, yeah, it wasn't so much of a recommendation, but more of kind of a general question. I've kind of made that assumption. And now that we have a new nickname for our communications director, I guess all of us that hear his voice will be smooth listeners, which is normally reserved for kind of those who follow jazz. You've heard that term, so thank you.
Any other comments for our prep team? All right, is there any public comment on this item? Again, this is item 8, update on our political reform education program. Thank you very much for your hard work.
Thank you.
Look forward to your next update. All right, we'll now proceed to item 9. This is our committee update. Commissioner Baker and I did meet as the Law and Policy Committee earlier this month to discuss legislation, which we will hear all about in item 10, which is Ms. Nakano's legislative update. We can now proceed to item 10, which is our legislative update by Senior FPPC Legislative Counsel, Ms. Nakano. While you're getting settled in, I do have one update. This morning, I had a conversation with Assemblymember Rivas, who is the author of Assembly Bill 975, and I appreciated her reaching out to let me know that she's going to hold the bill this year and to continue working with us to refine that bill's provisions. And so that's something I know staff will be doing in the coming year, and I really appreciate her outreach and continued engagement with us. That update, I'll turn it over to you, Ms. Nakano.
You're talking about AB 975?
I am.
Yeah. Okay.
Thank you, Mr. Chair, and nice to see you, Commissioners. So we are in the final weeks of session, and staff has been working closely with legislative offices and stakeholders on various commission-related bills. Today, I'll provide an update on all of the remaining bills that affect the FPPC. As I go through the bills, I'll indicate which bills the Commission has not taken a position on, and the Commission may discuss these bills further and may decide to take a position today. Because the Commission has also expressed a strong interest in bipartisanship, I'll also note recent vote counts and highlight where there has or has not been bipartisan support. First bill of the day is AB 775 by Assemblymember Berman, requiring affirmative consent for enrollment in automatic recurring campaign contributions. This is a Commission-sponsored bill, and moving this bill forward has been a major priority for the Commission. I'm pleased to report that the bill was amended this week with amendments that have been in discussion for many months. First, the amendments clarify when a violation occurs. A violation occurs for each improper solicitation and the initial acceptance of an improperly solicited contribution. Additionally, a violation occurs when the candidate or committee accepts subsequent improperly solicited contributions and they knew or should have known about the improper solicitation, and the recurring contributions exceed $1,000 in the aggregate. For these latter violations, the penalty is up to 3 times the amount of the aggregate contributions. Second, the amendments also require improperly solicited contributions to be returned within a specified time period, specifically 14 days from a request from the donor or from the committee independently finding out about its own mistake. Third, the amendments add an exception to the bill for a sponsored committee soliciting or accepting contributions from the sponsor's members, affiliates, employees, or shareholders. So this addresses the concern that I had raised in previous meetings from organizations that were concerned about
collecting contributions through things like membership dues. The amendments also add a definition of recurring contribution and add a Republican co-author, Assemblymember Cunningham, making this a solid bipartisan bill. And I'll pause here for any questions or discussion on AB 775.
Any questions or comments for Mr. Kano?
Just thank you for keeping us advised. It's really helpful to just know how much you've got a pulse on what's happening with this. It's over, hopefully, the finish line.
Okay, thank you. For the next two bills, there have been no amendments, so I just have status updates. AB 1798 by Assemblymember Bryan, another commission-sponsored bill, which would make minor changes to the campaign advertisement disclosure rules, is currently on the Senate floor awaiting a vote. AB 2172 by Assemblymember Cervantes, also commission-sponsored, would allow reports and statements under the Political Reform Act that are currently required to be filed on paper with the SOS to instead be filed by email with the SOS. This bill passed off the suspense file in the Senate Appropriations Committee with a unanimous bipartisan vote and is currently on the Senate floor. I'll move on now to other commission-related bills. As the chair mentioned, AB 975, did you mention this? Yes, you did mention this. AB 975 is on hold, and we will be working with the author's office moving forward. The next three bills listed in the report are bills that...
Oh,
yes, that's right.
Yes. You're definitely on top of these bills more so than I am. But before today's meeting, I pulled up the status of AB 975, and I don't want to get ahead of you, but if you know the current status, I think that would be helpful. On the Senate floor, correct?
Yes, it was on the Senate floor. There was a vote, and it did not pass. I think there was some discussion about what to do next, and the most recent news is that they are not moving the bill forward, but will bring it back next year.
Right, because my understanding that because it amends the act, it would require a two-thirds vote. Okay, thank you.
Thank you.
Good.
I think since we're on this bill at this moment, I do want to also thank the chair for engaging so much on the details of the bill with our senior legislative counsel, and thank the author for reaching out to us, as I understand that, about what to do, and I appreciate the author for doing that. I know they've been working hard on this, and I think we'll want to make it a priority to do as much as we can to have a good bill that the author will feel good about and we'll feel good about. So kudos to not only our team, but the author as well for working with us.
Any other comments? All right, Mr. Kano.
The next three bills listed in the report are all bills that the Commission has previously voted to support. These are AB 1783 by Assemblymember Levine, expanding what activity is considered lobbying. AB 2158 by Assemblymember Mike Fong, relating to ethics training for local educational agencies. And AB 2528 by Assemblymember Bigelow, relating to incorporating local campaign filings into the Secretary of State's online filing system. All three of these bills passed out of the Senate Appropriations Committee with bipartisan votes. The first two had a unanimous vote, 7-0, and the third passed with a vote of 6-0, with Senator McGuire, a Democrat, not voting. The next bill is SB 459 by Senator Allen. It's sponsored by California Common Cause and relates to increasing transparency about lobbying activity. The bill is a two-year bill and was brought back from last year. It passed in the Assembly Appropriations Committee with Republicans voting no. So for purposes of highlighting bipartisanship, I'll note that 3 Republicans voted aye on this bill previously on the Senate floor. The bill was subsequently amended on August 15th. Because it has been several months since the commission has discussed this bill, I will go over all of the substantive changes in the bill to existing law, including the recent amendments. The first change relates to periodic lobbying reports. Existing law requires lobbying firms and lobbyist employers to file periodic reports on lobbying activity. SB 459 would add additional specificity relating to identifying the legislative or administrative actions that must be included or identified in the report.
The second change creates more disclosure in the final 2 months of each legislative year. The bill would require that in the last 60 days of the legislative session, a lobbyist employer that hires a new lobbying firm and promises payment of over $5,000 to submit a new report within 48 hours and include in that report who was hired, the amount of the payment or promised payment, and the identity of the legislative action, such as the bill number. The purpose of this report is to provide more disclosure in the final weeks of each legislative year, since much of that activity would otherwise only be reported after the conclusion of session. The third change regulates the novel area of lobbying advertisements. The bill adds a new section. It defines issue lobbying advertisements to mean a general or public communication made for purposes of influencing a legislative or administrative action, including an advertisement soliciting or urging a person to communicate directly with an official for the primary purpose of attempting to influence a legislative or administrative action. So in short, in essence, this new section regulates ads that urge support or opposition for a legislative or administrative action. The bill requires these ads, issue lobbying advertisements, to clearly and conspicuously identify the person that authorized and paid for the ad. This is similar to disclosures required on campaign ads. The bill would also require a new report for any person who pays or makes enforceable promises to pay $5,000 or more in issue lobbying ads in a calendar quarter. The report would be due within 72 hours to the Secretary of State on the online filing system. The report is required to include total payments, the date of the dissemination of the ad, the identification of the legislative or administrative action, the support, oppose, or similar position urged on the ad, the method of disseminating the ad, and the name of the legislator or candidate that was clearly identified on the ad. Last, also relating to issue lobbying advertisements, the bill would require lobbyist employer periodic reports when reporting payments to employees of $2,500 or more in connection with an issue lobbying ad, to include in those reports identification of the legislative or administrative action, for example, the bill number, and the support, oppose, or similar position of the lobbyist employer. The Commission has not taken a position on this bill. At the time of the last Law and Policy Committee meeting, the amendments were forthcoming, so the committee held off on any discussion of a possible position. The recent amendments removed opposition from SEIU, CSEA, and CFT, but some opposition remains, including from the California Political Attorneys Association and an opposed unless amended position from the California Medical Association. The bill has support from several good government groups, including California Clean Money Campaign, League of Women Voters of California, and again, it's also sponsored by California Common Cause. I'll pause here for any discussion.
Thank you, Mr. Cotto. That was a lot to explain to us, but I appreciate you doing it in a very understandable way. I have one question for you. I was looking through the bill, and it has to do with the effective date. Substantive provisions that you describe, I think, certainly would improve transparency greatly with respect to lobbying activity and issue ads. I know Section 7, though, says, if I'm reading this right, none of those provisions actually go into effect until 1 year after the Secretary of State certifies an online filing and disclosure system pursuant to 84602. Does that mean that these new lobbying reports are not going to begin being filed until a year after the new Cal Access replacement system is certified as being operable?
That's correct. But the bill does have a delayed operative date that's contingent on this new system being certified by SOS, so it would be potentially several years out.
Okay, I just wanted to clarify. That's not to say that I don't. I support the substantive provisions of the bill. I just want to make sure we had an understanding of.
Thank you.
Do other commissioners have questions?
Just for clarification, for the public's benefit, if anyone was listening to the exchange, if you could just reiterate the bill number.
Oh, of course. This is SB 459 by Senator Allen.
Correct. Commissioner Wood, anything you want to add on this bill?
No, thank you.
So, Ms. Nakano, as you mentioned, we had not previously taken a position on this bill. We were awaiting these amendments. At this time, I would move that we support Senate Bill 459.
Second.
A public comment on the motion before we vote.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. All right, Ms. Nakano, please proceed.
Thank you. The next bill is SB 746 by Senator Skinner. The bill passed out of the Senate Appropriations Committee 15-0 and was heard yesterday in the Assembly Elections Committee. It passed with a bipartisan vote of 6-0 with one member absent. The bill was also recently substantively amended on August 11th and again on August 15th. The bill would now require a business entity to submit a report to the Secretary of State's office if the business entity uses its products or services to alter its online search results in order to emphasize or de-emphasize materials containing express advocacy, or uses its products or services to target online advertisements to individuals or groups without payment and for political purposes. The purpose of this bill is to address instances where a business, such as a social media company or a search engine company, alters its results or targets alters search results or targets political advertisements on its own initiative without being paid by a committee. If the business was paid, these payments would most likely be reported by a committee, so this bill aims to get transparency regarding this other non-paid activity. This bill also has a delayed implementation date of 1 year. It would become effective January 1st, 2024. The Commission hasn't taken a position on this bill. Similar to the previous bill, at the time of the Law and Policy Committee meeting, amendments were pending, so the committee did not discuss a position at that time, but I'll pause here for any discussion.
Thank you, Mr. Kano. For my part, I think, I at least myself, I rely on online search engines all the time, and I think it's important that people understand if those search results are being intentionally targeted one way or the other. And so I think for purposes of, again, improving transparency, this is a bill that we ought to support, but I'd like to hear what my colleagues think. Anybody?
No, I have no objection. I mean, it's quite a bit different than what it was even, 10 days ago. The bipartisan support, if I remember correctly, the votes, there were no votes on this?
That's correct.
In its current form. Because it's only been heard by one committee.
That's right.
Understood. Thank you.
All right. I would move that we take a support position on SB 746. Public comment on the motion.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. The next bill is SB 794 by Senator Glaser. This bill would allow a committee to knowingly accept a contribution that is over the applicable contribution limit in the Act, as long as the committee returns the excess portion within 72 hours and does not make use of the contribution prior to returning the excess. The bill also caps the amount that can be initially accepted to twice the applicable limit. The bill was recently amended on August 11th to allow committees to attribute the excess portion of the contribution between the primary and general elections or to another election with written permission from the donor, which mirrors federal law. The amendments would also require a committee to notify a donor when that donor gives a contribution that exceeds the limits. Generally, the purpose of this bill is to allow a committee that receives an over-the-limit contribution to retain the amount they're allowed to accept, and then either return the excess or attribute it to another election within the contribution limits and within the specified time period. On August 4th, at the last Law and Policy Committee meeting, the committee voted to recommend that the Commission support this bill, SB 794. And I'll pause here for any discussion from the Commission.
Thank you, Mr. Kano. This is a bill where I think when we first reported on this bill, we had some questions and some ideas for improvements. It's my understanding that Senator Glaser and his office worked with us to address those concerns. Those amendments have been made. Is that correct?
That's correct. We've been working closely with Senator Glaser's office. He's accepted a lot of our changes, and it's been, it now reflects, I think, resolves a lot of the concerns that we had.
Other commissioners have questions or comments on?
No.
Commissioner Wood?
No, no, I'm fine. Thanks.
Then I would move that we accept the Law and Policy Committee's recommendation that we adopt a support position on Senate Bill 794.
Second.
Public comment on the motion. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
For the final three bills, I have status updates only. For the SB 1352 by Senator Allen, which would have required a third pre-election statement, was held in the Assembly Appropriations Committee, meaning the bill will not be moving forward this year. SB 1360 by Senator Umberg relates in part to advertisement disclosures under the Political Reform Act. The bill passed in the Senate Appropriations Committee with Republicans voting no, though I'll note that the bill did previously receive 4 Republican aye votes on the Senate floor. The bill is now currently on the Assembly floor awaiting a vote. Last, SB 1439 by Senator Glaser relating to agency officer contributions and disqualification passed in the Senate Appropriations Committee with Republicans not voting. So I'll note here as well that 4 Republicans voted aye on the Senate floor. The bill now also awaits a vote on the Assembly floor. And that concludes my legislative update, but I'm happy to take any other questions.
Thank you, Ms. Nakano. And let me just say, I want to thank you and compliment you on your work this year on our legislative items. I know, as we saw today, there were some last-minute amendments that were extensive. You were able to brief us on those in a very understandable way, and appreciate that. And just throughout this legislative cycle, really appreciate all of your hard work for us.
My pleasure. Thank you.
Any other questions or comments for Ms. Nakano?
No, I would just, concur with the chair's comments. Thank you.
Here, here.
All right. Thanks, Ms. Nakano. I'm sure we'll see you in a couple months.
Thank you.
All right, we'll now proceed to item 11. These are our executive staff reports, and we will begin with Enforcement Chief Brereton.
Hello again.
Good afternoon.
I wanted to point out that on our executive staff report for enforcement, I believe it's on page 4, we have added the July quarterly numbers, and it shows that we're still making good progress on our older workload, and hopefully we'll continue at this pace or even faster as we head through the end of the year.
Thank you, Chief Brereton. Any questions or comments for Chief Brereton on her report? Thank you, Chief Brereton. Move next to our Audits and Assistant Division report. And welcome back, Chief Shaw.
Hello again, Commissioners. My report is as submitted. However, I do want to highlight that going forward, starting with this month's report, we will be including details of any audits that we have completed and the audit reports that we have adopted. So starting with this month, we have included one audit report details that we have adopted, and then going forward, that will be the format that we will continue.
Thank you, Chief Shaw. Can you, now that we're including completed audits in your report, can you just give us a sense of, once we see it in your report, what happens next to that audit?
So our general practice is once we adopt a report, the report goes out to the person that we are auditing, obviously, the candidate, excuse me, and then any other required individuals that we need to send it out to, and then we submit it to our enforcement division. The enforcement division reviews the report and then decides, based on the findings that we have, if they need to open up a new case or if they can close the audit at that point. And then if they do open up a case, it goes through their process of, they will obviously have a new case open, and then they will do their process of evaluating the findings and then going forward with that. If that doesn't happen, they will notify us that they have closed out the report, and we will close the audit out on our side.
Thank you. Appreciate that. Any questions for Chief Shaw?
All right. Thank you.
Thank you, Chief Shaw. And next, we'll move to the Legal Division report. General Counsel Bainbridge.
Just one thing to point out that's in the report under pending litigation. This was a case where we prevailed back in March at the trial level. The petitioner in that case has agreed to forego their appeal, so the matter has been concluded, and you won't see it on this report again, so I thought I'd just note that before we take it off.
Thank you, Mr. Bainbridge. I would also just note, for the benefit of the public and the other commissioners, on well, it's listed as page 9, but it's the first page of your report, the extensive outreach and training that staff have been doing recently. I just want to, again, compliment our staff for the proactive efforts that we're making to make sure that people get the benefit of the trainings that we. Right. Let's move next to our Admin and Technology Division report. Sitting in for Chief Hahn today is Ms. Ju. Good afternoon. I think you're on mute, Ms. Ju.
Sorry. Good afternoon, Chair. Good afternoon, Commissioner. This is Ju Wen, Admin Manager. So I would like to submit admin report as it is. I'm happy to answer all the questions you may have.
Thank you. Any questions for Ms. Ju? All right. Thank you very much.
Thank you.
And last but not least, Executive Director West.
Hello. So I don't have anything to report myself, but I would like to introduce the smooth voice of the prep program, Mr. Jay Wairenga, who is going to give us an update on our outreach with PSAs.
Good afternoon, Chair, Commissioners. Jay Wairenga, Communications Director. And first, a note that I have no idea what the Executive Director, Chloe, was talking about. It was all the work of computerized voice enhancement technology. So that's exactly what happened. All right. So for background, if you recall, 2 years ago, we hired a team to create a PSA, a 20-second public service announcement that's rather evergreen. It targets who's behind the political ads, we can help, and then there's a link to our website election page afterwards. In the spring, we ran it a limited run on some McClatchy sites around the state and on some other ad platforms, as well as we began to run on Google, which Sasha maintained. And so here are the results as we go to the first slide. There we go. So the more than 100,000 people saw our PSA on the McClatchy run. The McClatchy sites themselves had about 2/3 of those, and our targeted audience group had about 1/3. The targeted audience was those specifically interested in government. And the click-through rate on here seems small, but it is about average for a run like this. The next slide, slide 2, are the specific McClatchy sites. Second slide. There we go. These are the specific sites, as you can see, and as expected, the Sacramento Bee had the most, as it is the largest subscription base. However, the Modesto Bee significantly overperformed, and the Fresno Bee came in also above average, with Merced and San Luis Obispo underperforming slightly, but the completion rate was all about 75%. So about 3/4 of the people who saw the PSA watched all or most of it. Our next slide looks at the targeted audience, and this group did not do as well as the general audience. We have some potential strategies for that for later this month in the fall that I'll get to. You can see we have a fair amount of video starts here, but a slightly lower completion rate and a lower click-through rate. I think it shows that many people started the video, but it wasn't exactly what they were looking for, so they didn't finish it. So our plan is to expand from just government to a more specific, like politics, campaigns, elections, political ads, instead of a more government in general kind of target. The next slide is another view of the same data in a graph form. You can see how the Modesto Bee really performed above average compared to all the rest of them. And the bottom two graphs there, clicks by site, show that in Fresno, we had the biggest return and people who actually clicked through and went to our website, with about 30% of all the click-throughs in the entire run. The next slide, slide 5, the top chart is a further breakdown from the previous on the specific sites around the state. Obviously, higher population areas like LA, San Jose, San Diego, Sacramento are going to have more views. But again, you can see with the blue chart in the background, we had spikes in Fresno, Modesto, and Clovis. So apparently we're very popular in the Central Valley, and we'll hope to spread that throughout the rest of the state. The bottom chart details the specific sites, not just McClatchy, but the other ones that were used through this ad run. As you can see, like HuffPost, Washington Examiner, Yahoo, USA Today, they all did fairly well. We're going to look into why the local television sites didn't do as well. They underperformed. So when we put our ad on their local TV websites, TV station websites, those did not do as well. So we're going to look into why that happened. But the NBC and Fox stations did better than the ABC and CBS stations. So we're going to try and look into why that happened. The next slide is looking at some of the Google analytics. So on Google, we had about 58,000 impressions, but only 27,000 views. So it was under a 50% view rate. The good news on that side, though, is that through Google, it's only pennies per view compared to the other. So if you want more views, you have to pay more, generally speaking. This slide shows what's obvious to most people. Most people look at it on their mobile. And the TV screen refers to kind of what the next slide will show. Slide 7 is the networks. They run a lot on YouTube, and a lot of YouTube videos, as our executive director pointed out to me from her anecdotal experience, sometimes you have to watch the whole thing before they let you move on to the next thing. So this is where it displayed on the networks. And as you can see, the cost per view is very, very low on Google compared to other sites. Slide 8, we're looking at some demographics from Google here. They look like this. From the ones that could be determined, younger men, 18 to 24, up to age 44, and then we did better with women, 18 to 24, and 55 plus, especially 65 plus being the top demo on this, along with younger men, older women. So, and finally, the time of day, no surprise, mostly later in the day on the last slide. Later in the day, later in the week, which is no surprise. And although dinner time Sunday seemed to be very popular as well, so hopefully we'll take on 60 minutes in that time slot. So overall, our general results, we are being seen, if not always acted upon, but being acted upon as average and expected for an ad run like this. We had more than 100,000 impressions with McClatchy, 58,000 with Google. And as mentioned, Google is cheaper, but we get more results with the more specific targets. So our next steps, we plan to expand this again for the fall. We will be running McClatchy again, and we will be doing runs with the LA Times as we did in 2020. And again, these aren't just their specific papers. It's all the ad breakthroughs that they do. And we'll be refocusing those efforts to target the audience more with political ads, campaigns, elections. And we'll also do another run with Google, and we have already started a run with Facebook that I believe Sasha started last week. Yeah, so we'll have the results for those after the November election. And if you want these slides, I can send it to Sasha. She can send it out to you guys. That's my report.
All right. Thank you, Mr. Woodringa. That's great that we're doing that and continuing to do it. And so the ways we can improve our target audience, that's something that you can implement ahead of the run for this year's general election. Right. All right. I'm definitely looking forward to see if that kind of moves the needle one way or the other.
We hope it will.
We do hope that it will. Any other questions or comments? Commissioner Baker?
Thank you. If we wanted to see this PSA, is it also available on our website somewhere?
Yeah, we will, I'll send it around, but we move a couple of our videos back and forth, the general one that the college student did for us, and now we can put the PSA back on the front page.
Yeah.
And we tweet that, I try to tweet that out every now and then as well.
Thank you.
Comments for Mr. Woodringa? All right, thanks, Jay, appreciate it. All right, that brings us to our final item, commissioner comments and proposed future agenda items. Do any commissioners wish to offer closing comments or future agenda items? Commissioner Baker.
Thank you. Not a closing comment, but for that future meeting where we, both at Law and Policy and as a commission, are considering legislation for next year. I did just want to underscore again, because it's nice that the team is tracking this for us so we don't forget. The issues we raised today on recall, for my part, certainly the look at the definition of candidates, kind of why I was going into constitutional versus statutory, and any of our other commissioner questions or input related to the recall for consideration, presumably September, October, I guess we start having that discussion. Thank you.
Any other future agenda items, closing comments? All right, with that, I will make a motion to adjourn. Do I have a second?
I can second.
Thank you, Commissioner Wood. Ms. Linker.
Aye.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Manich?
Aye.
The motion passes.
All right, thanks, everyone. We'll see you next month.
Thank you.
Thanks, guys.